Good morning everyone, my name is Michelle. I hope you're doing well. Welcome to another video. It is Tuesday morning, the 6th of February. I'm going to be talking about the latest court filings in the Delphi case today. But before I do, I'm going to direct you over to my other channel, my second channel, Michelle Walks. Because on Michelle Walks, I'm going to be concentrating on the Adam Montgomery trial. This is Adam Montgomery. He is accused of murdering his then 5-year-old daughter, Harmony Montgomery, in 2019. And this case has finally got to trial. So I'll be doing daily videos about the trial. I won't be streaming the trial live because I can't commit to that because I've got other commitments and stuff. I can't commit to that. So I'm going to be doing daily videos or a live stream. So some days it'll be a recorded video, some days it'll be a live stream. The jury selection starts today, but when the trial starts proper, that's when the daily videos will start on Michelle Walks. All right, so if you're interested in the Harmony Montgomery case and the Adam Montgomery trial, then please do keep checking on Michelle Walks. I know people don't get notified about videos that I put on this channel, but I do a lot of content across a wide range of cases on this channel. So for the duration of the Adam Montgomery trial, there will be daily videos or a live stream. Also on Sunday on this channel, Michelle Walks, there will be episode 35 of Crime Story Sunday, which will be Maura Murray, because it's the 20-year mark of her being missing. So that is Sunday, 8 PM UK time. All right, let's get on with the Delphi case.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Okay, so there's been 2 new court filings. It's like waiting for a bus. None of them come for a while and then multiple filings turn up on the same day. So if you've been following this case, you will know that Slick Nick, prosecutor Nicholas Charles McLeland, he submitted a motion for contemptuous conduct, contempt of court. But unfortunately for Slick Nick, there was already a motion in to disqualify the judge, Judge Francis C. Gull. So it's all a bit of a mess, really. Now, Francis, good old Francis, consistent with her previous form, has ignored the motion to disqualify her and gone straight to a hearing for the contemptuous conduct. And she set that for February 12th, 9 AM at Allen Superior Court, which is her court, not in Carroll County, where the case is being held. Anyway, a couple of days ago, attorney Brad Rosie put in a motion for continuance with a bunch of reasons why the 12th of February wasn't suitable. So they filed another motion for continuance. This time it's from both of them. So I'm going to read this, and there's an important piece of information in here that I think we need to consider a little bit deeper. Attorney Rosie and Baldwin state the following. On January 18th, the state filed an amended charging information and motion for leave to amend said information. So this was the upgrading of Richard Allen's charges from 2 counts of felony murder to 2 counts of first-degree murder. They kept the felony murder on the book, so the jury has a choice of 2 different statute numbers. Also, separate charges for kidnapping. On February 1st, the court issued an order setting the state's motion to amend for hearing on February 12, 2024 at 9 a.m. Not only was it for the contempt allegations, it was also to amend Richard Allen's charges. So this document is all about that. Okay. At the time of filing of the amended information, Attorney Rosie and Attorney Baldwin were not acting as Richard Allen's lawyers. It was approximately 6 hours later that they were reinstated as Richard Allen's lawyers in this cause. I don't think that matters. I think that's splitting hairs, honestly. This is the important bit here. As of the date of this motion, attorneys Rosie and Baldwin are in the process of recovering the voluminous discovery in this cause. The recovery has involved the transfer of information from attorneys Scremin and Labrato to prosecutor McLeland and then to attorney Rosie's office. The discovery must then be shared between attorneys Rosie and Baldwin, whose law offices are separated by nearly 100 miles. It's a bit of a business to transfer all of this paperwork. I mean, you know, some of it will be electronic, but there'll be all the paper copies. There'll be boxes and boxes that have to be shunted around. They can do that. All right. But this is the thing. In addition to recovering discovery that was previously possessed by attorney Rosie and Baldwin, the prosecutor's office has now directed additional and what appears to be new discovery to attorneys Rosie and Baldwin. The new discovery, upon initial review, appears to be quite voluminous and will likely take several weeks for attorney Rosie and Baldwin to review. There is also the difficulty in communicating with their client regarding the new discovery, considering the distance between the client and the lawyers. Apparently, at Wabash, you can video conference him. Did you know that? Yeah, with guards hanging over him. I'm going to come back to this. There's more in this document, but don't you worry. That's the bit I want to talk about. Without having an opportunity to review the entirety of the new discovery, attorney Rosie and Baldwin have no way of determining whether or not the amendments will prejudice the substantial rights of the defendant. Attorney Rosie and Baldwin, private practitioners, therefore have other clients and responsibilities. Okay, some of these priorities involve client conferences and scheduled hearings set the week of February 5th. Because she didn't bother to check with them whether the date would be okay. She just assumed. And attorney Rosie is out of the state of Indiana on February 12th on personal matters. So any reasonable delay allowing for attorney Rosie and Baldwin to get back up to speed, exchange discovery, communicate with defendant Allen and review the new discovery would not be of any detriment to the state. On January 29th, defendant Allen filed his verified motion to disqualify an accompanying affidavit. The filing of a motion for disqualification and or request for recusal strips the court of jurisdiction to decide on any matters until a ruling on the disqualification motion occurs. Therefore, it seems logical that the motion to disqualify will be fully adjudicated before any further hearings take place. However, there's more, because attorney Baldwin has filed this on the same day. This is just by Baldwin, and this is a motion to vacate the hearing completely. The defence filed a verified motion to disqualify on January 28th at 10 p.m. The state filed a verified information for contemptuous conduct on January 29th at 4:34 p.m. So they had the motion to disqualify in first, right? Cool. Upon the filing for disqualification, the court was divested of jurisdiction to act in the case on any matter other than the motion for change of judge or emergency matters. On February 1st, the court set the state's request to amend the charging information and their allegation of contemptuous conduct. Before the court takes any action, there should be a hearing for the motion to disqualify. Therefore, the accused respectfully prays the court to vacate the February 12th hearing and schedule a hearing on the motion for disqualification. Okay, but let's just ponder on this for a minute, shall we? New discovery. Voluminous, they like that word, voluminous new discovery that Slick Nick has just kind of slipped in there. The original deadline for all discovery to be transferred was the 1st of November. I was under the impression that Slick Nick had sent all of the discovery to the defence before that date. And I say this because the trial was due to start on January the 8th. Of course, we all know it didn't. It should be like well underway or even ended by now. But no, because of all of the events that went down in October. But now we're in February and Slick Nick has decided to send over a whole bunch of voluminous new discovery. So where has all this new discovery come from? Like, was it down the side of his couch and he'd just forgotten about it? Was it in the boot of his car and he'd just forgotten about it? Maybe the odd paper you might have overlooked. But voluminous discovery? I mean, just how many pages does voluminous actually cover? Where has all this new evidence within the discovery come from? Because Slick Nick, only a few days ago, filed for the defence to hand over their discovery. Because he'd handed over his, and he wants theirs. Okay, that's fair enough. But where's all this new discovery from the state come from? Where's all this new evidence popped up from? It's nuts. Is it all like the results of like things like DNA testing of Patrick Westfall and all that, like those ordinance lot? Is it that? What is it? What is it? Are you just now making stuff up, assuming that he isn't just making stuff up? I know people will accuse him of that, but you've got all this new evidence that wouldn't have gone to the original trial. What if you don't like a complete new investigation? If you have, is Richard Allen still your main man? Is it relating to the upgraded charges? Your guess is as good as mine. Let me know in the comments what you think. Crazy days. I'll see you in the next video. Bye, guys.